We are thrilled to have everyone in attendance. I'm Rebecca Bernhardt.
And I'm Catherine Strandberg. I'm the criminal justice analyst here.
And we're going to talk through really the highlights of the legislative changes as they relate to our sexual assault agenda. So let's get started. So most of y'all know about TAASA. TAASA is a statewide advocacy organization that addresses, works to address and eliminate sexual violence. Particularly, we are from the policy team, and the policy team advances the public policy interests of sexual assault survivors through research, education, lobbying, advocacy, and grassroots organizing. We are hoping through this webinar that you'll get a better sense of not just the outcomes of the legislative session, but what we do and how we do it, so that when you participate as a member in voting on what our agenda is and in making decisions, you have a better sense of how that feeds into our process and sort of what's going on, during our legislative work. We're having a slight technical difficulty. Yay. Okay, we'll keep moving.
Okay, so the process of creating and then passing a legislative agenda starts actually now. As opposed to most state legislatures, Texas only meets every 2 years. So we have about 18 months to think about and plan what we want our agenda to be in between sessions. About 18 months before session even starts, we start to develop a list of questions and issues that we think that task forces, legislative committees, and other stakeholders might have a role in thinking through and creating potential solutions to. In the 6 months before session starts, we've typically identified a handful of major policy problems and their potential solutions. And we've done that through task forces that are set up by community organizations or by members of the legislature. We've done it through membership surveys, and the legislature itself spends some time thinking around policy problems in something called interim charges, which is a more formalized way to think about an issue that was raised during the previous legislative session. So in the 6 months before session, we've identified some key problems, and we've also identified which lawmakers would be good to collaborate with on potential solutions. This is also the same time that membership votes on our policy agenda. So when you get that document in August or September before the session starts, that's when we decide which 5 priorities are most important for us, the policy team, to pursue during session. So even before a bill gets written, we have to shop our agenda around to interested parties. And there are some legislators that we have good, long working relationships with, and some newcomers who are particularly eager to do some creative thinking around the problem of sexual violence in Texas. And then a little before session starts, we end up writing bills with lawmakers that will reflect our interests and identify both the problem and what we think is a possible solution to that problem. Because bills get their first chance at success during committee hearings, this is also the time in which we go to committee offices, introduce ourselves to the staff, tell them who we are, and start to develop those relationships so that when bills come up in committee, we're already a trusted voice to talk through those bills with them. And that's when the fun really begins. So most folks estimate that a bill only has a 5 to 10% chance of passing during the legislative session once they've been filed. And as you can see here, it's a lengthy and complicated process. So say if a bill is filed in the Senate, it's then heard in committee, and then if the committee votes to pass it out of committee, it's placed on the intent calendar, and then it's debated on the floor of the Senate before it goes to the House committee, and the process starts all over again. If the bill changes considerably during that process, Then it has to go to something called conference committee before it's ever signed by the governor. So of the priorities that our membership asked us to pursue last year, 4 out of the 5 of them we were able to pass. The first was to fund sexual assault programs, to ensure that every rape kit is counted and tested, to create a criminal offense for indecent assault, and to improve medical care and due process for survivors. And I'm going to let Becky get into the nitty-gritty of these.
So as it might already appear, we had a really successful legislative session. The bills, just to sort of give you context, the bills that our membership decided were membership priorities have a teal star next to them on these slides. So those are the 4 that Catherine just mentioned. It's a really big deal that we were able to get new general revenue funding for a couple of our priorities. We talked before the legislative session to rape crisis centers and found out that many of them had wait lists for key services for survivors. And we were able to take that information to the legislature and get $7.7 million in new general revenue funding to address those wait lists. So hopefully going into the next 2 years, our rape crisis centers will no longer have wait lists for their key therapy services. An even bigger investment was made by the legislature to address rape kits, which have been a huge issue in terms of identifying how many we have and making sure that they all get tested. This is frequently referred to as the backlog problem. We don't like to use the term backlog because that doesn't really describe what's happened with the rape kits. So in Texas, we have now dedicated $60 million new dollars in appropriations to build the capacity in both public and private crime labs to test these rape kits. And we have new legislation that's also going to help make sure that we identify where all the rape kits are and make sure that they get tested. So this is a really big deal. We also have legislation from the 85th legislative session that creates a new kit tracking system. So for all new rape kits, they will go into the kit tracking system, and survivors and prosecutors and law enforcement will be able to see where the kits are at any point in the process of them being tested and used as evidence in a case. So all of this is really exciting, good stuff. As Catherine mentioned, we also created a new criminal offense for basically a sexual assault that's less than a less severe assault, like a groping offense. It's Senate Bill 194 by Senator Perry. It's a Class A misdemeanor, which means that it's up to 1 year in jail for indecent assault. We also, with the help of Chairman Nelson, passed SB 71, which establishes a statewide telehealth or how do you say? Yeah, telehealth center. I'm not sure that there are better words for that, to connect survivors via the web to high quality medical care through video to certified SANEs. So those were the 4 of our 5 priorities that passed. Unfortunately, we had a protective order bill that would have improved access to protective orders for survivors that did not make it through the legislative process. It died in the calendars process in the House, which was really unfortunate. That's frequently how bills don't make it through the process, is that there's just not enough time for them to survive or to get all the way to the governor's desk. We're going to keep working on that piece of legislation, but largely it was an incredibly successful legislative session for us. And so we're super excited to share all of this with y'all.
So I'm going to talk about 2 big pieces of systems level legislation that will change the way that Texas deals with sexual assault on a larger scale. The first is the Lavinia Masters Act, or House Bill 8 by Representative Victoria Neave. And this reflects both agenda items 2 and 4 to ensure that every rape kit is counted and tested, but also ensuring access to due process for survivors. This omnibus bill, an omnibus bill just means that there's a bunch of different pieces of legislation around the same topic in the same bill. So it tends to be larger, more robust, and more expensive than ordinary pieces of legislation. And this omnibus bill is a product of the task force that Representative Neave set up during the interim between the last two sessions to really think through, okay, so we have this backlog of kits. DPS is moving too slowly to test new forensic evidence. And the more backlogged kits that we put into DPS's pipeline, the slower this is going to be for all kits. And thinking through, okay, what pieces of this do we invest in? How can we give survivors a better understanding of where their kits are in the pipeline? And really sat down with DPS, some other stakeholders, folks from crisis centers, SANE nurses, to think through this complicated process and develop really sophisticated solutions to fix it. So it does a couple of things. The first is that it establishes new timelines for the collection, preservation, and submission of forensic evidence for analysis. So it does it at a couple of different points of exchange of forensic evidence between different stakeholders like nurses or investigators or the labs themselves. But an example of that is that law enforcement has to take possession of evidence from the clinic or hospital within 7 days or 14 days in more rural places. And it extends the statute of limitations for sexual assault cases in which the evidence has not been submitted for analysis. So the time clock on your statute of limitations doesn't start moving until evidence has already been submitted to the labs. It requires a new statewide audit of untested evidence kits. Historically, we've already had one audit to understand better where we were with backlogged kits. And while our major jurisdictions complied with the audit, a lot of smaller jurisdictions around the state didn't submit the number of kits that they had sitting on shelves. So this new audit ties access to some law enforcement grant money to, sorry, I saw a question pop up and I lost my train of thought, I'm sorry. So it ties the new audit to conditional grants to law enforcement to make law enforcement agencies more likely to comply with the new audit. It also requires the Department of Public Safety to submit a report detailing a projected timeline for completing evidence testing and a request for any more necessary funding. So we're investing a lot of money in the Department of Public Safety right now, and this bill wraps around those new investments to say, okay, so we are giving you this money should transform how quickly and how well the Department of Public Safety is testing evidence. And if there's still some shortcomings, we need to better understand where they are so that if we have to invest again to further this process, we'll understand exactly where and how we need to do that. It also provides that the Department of Public Safety should preserve evidence that's collected in non-report cases for up to 5 years, and prohibits the Department of Public Safety from destroying such evidence unless they've given the survivor written trauma-informed notification of that decision and instructions on how to say, no, I want you to hold on to my evidence. I'm still thinking about filing a police report around it. The other big piece of systems-wide legislation is House Bill 1590 by Representative Donna Howard that created the Sexual Assault Survivors Task Force. And that is a big state-level task force that is going to be held in the governor's office through 2023. And it is charged with studying responses to sexual assault in Texas. We have about 16 key stakeholders around that table. We're starting to get folks involved now. And we actually don't even know what kinds of issues they will end up really studying. But the first two big things that they have to do is resource mapping of how we're responding across the state to sexual violence. So that means the crisis centers that we have on the ground, really helping folks, how law enforcement is interacting with those crisis centers, where we need better supports for survivors. And it also asks the state auditor to develop an audit plan to better understand the process from an initial police report to the prosecution of sexual assault, because we know that report and prosecution rates are typically very low in Texas and nationally, but compared to other kinds of crime, we want to better understand what barriers are happening for law enforcement and for prosecutors. So the state auditor is going to develop this audit, and then we'll have these two big things, the resource mapping and then this audit, so that we can understand where we are as a state, and then direct the task force to develop good questions around that knowledge. So we're really excited about both of those things. We think it'll give us a great picture of where the state is.
So now I'm going to talk a little bit about 3 pieces of legislation in the area of higher education. What's really been driving legislative interest in the higher education arena has been the Baylor sexual assault scandal, which occurred several years ago, and changes in the Title IX sort of framework because of the change in administration at the federal level. So since Title IX enforcement and the rules around Title IX have changed, and there's really, this administration is really weakening the protective framework that Title IX used to represent at the federal level. The state is, or at least some state legislators are really looking to put new laws into effect at the state level to fill that gap. So the first piece of legislation is House Bill 1735 by Representative Howard and Senator Watson. It is a really good example of legislation that is really trying to fill the gap left by the federal government abdicating responsibility under Title IX. You could describe it as Texas's Title IX. It is also a result of a huge amount of student involvement and input. There are a large group of student activists who provided a lot of feedback about what would be really valuable in terms of legislation, and they were heard. And so this piece of legislation is really a reflection of their feedback. They also testified at every stage in the process and were really the heroes of this legislation. This legislation requires all public and private institutions of higher education to adopt a policy on sexual assault, sexual harassment, dating violence, and stalking, and sets out minimum requirements for institutions handling violence and harassment on their campuses. It does a lot of things. We're really sort of summarizing it. So if you're interested in it, we are probably going to be doing a webinar just on this piece of legislation and the other pieces of legislation that have to do with higher education, because there really is a large amount of changes that they reflect in terms of legal changes. So the second piece of legislation in the higher education arena is Senate Bill 212, I'm sorry, by Senator Huffman and Representative Morrison. This piece of legislation is a bit more of a mixed bag. It changed as a result of the legislative process. It started out as a piece of legislation that was going to require all employees and the heads of student groups, so that would be students, to become mandatory reporters. And we worked a lot with the author to change the legislation so that it would only require employees of an institution of higher education to report incidents of sexual assault, harassment, dating violence, or stalking to the Title IX coordinator or deputy Title IX coordinator of the institution. It's a bit draconian in that it actually has a criminal penalty for someone who fails to report. At the same time, it fills a gap in that the changes at the federal level in Title IX, which are really discouraging reporting, are a bad thing. And SB 212 will really make sure that reporting is happening in the state of Texas. It also requires institutions to report the number of incidents that get reported to them, and do that publicly, so it'll give us a sense of what's going on at universities. So the final piece of legislation in this area of higher education is House Bill 499 by Representative Turner and Senator Watson. It's a much smaller piece of legislation. It really very much focuses on the concern that students who were accused of sexual assault and found accountable for committing a sexual assault on at an institution of higher education would then move to a different campus and move to that campus with a clean slate, with the new campus having no awareness of what had happened at the previous institution. So House Bill 499 just requires that post-secondary education institution to include a notation on the student's transcript indicating that the student is not eligible to re-enroll at the university or college for a behavioral reason. It doesn't say what the behavioral reason is, it just says that there's a reason why the student can't re-enroll. So that's it for higher education.
Okay, so in addition to what we spoke about with House Bill 8, or the Lavinia Masters Act, there's a few other new laws around sexual assault and nurse examiner or forensic exam access and the financial systems that support these programs. The first two of these are related to increasing SANE access in more rural parts of the state, since 84% of Texas counties don't have a SANE program. So historically, beefing up SANE access, having more SANEs at more rural hospitals has been the way that we've tried to pursue this. Unfortunately, in a lot of more rural programs, having a SANE nurse there is either too onerous because having one person constantly on call is really hard to keep that person staffed there, or they just simply don't see enough sexual assaults every year to become deeply experienced. Or even that having a couple of people there, there's just not the funding for it. So one way that we've decided to pursue better SANE access across the state, but in particular in more rural parts of the state, is through a statewide telehealth hub. So Senate Bill 71 by Senator Nelson will functionally connect survivors with high quality medical care from certified SANEs first biennium. So what this means is that we will be building a place where very high qualified, very experienced SANEs can be piped in via video conferencing to a hospital or a standalone clinic where a forensic nurse who's had some training on trauma-informed care and forensic collection will be advised by the more experienced SANEs so that the care that survivors receive is more trauma-informed and so that they have a better chance of collecting all of the forensic evidence that they possibly could. There's also a $6 million rider passed by Representative Howard to establish a grant program to provide awards up to $50,000 to support Safe Ready facilities and support facilities in becoming Safe Ready. So something that we've heard from SANEs in our collection of data about how to better increase SANE access is that they lack an administrative capacity, or that having to do administrative work was becoming a drain on their ability to do the real SANE work. And so this money will help increase administrative capacity, get some better systems online, make their lives a little bit easier, hopefully. House Bill 616 by Representative Neave enables SANEs and healthcare facilities to apply directly for reimbursement from the Crime Victims Compensation Program instead of requiring reimbursements to flow through law enforcement agencies first. So functionally what this means is that SANE programs are telling us that the length of time between doing an exam and being reimbursed for it was too long, and it was affecting their ability to grow their programs, because as it stands, a SANE has to apply to the law enforcement agency, who then has to apply to the Attorney General's office for reimbursement, who then reimburses the law enforcement agency, who then reimburses the SANE program. And that lag time was really hobbling programs from scaling up. And so this allows SANE programs to directly apply to the Attorney General's office. Those new forms will be coming online very soon because this law is effective as of September 1st. So hopefully that turnaround time for reimbursement is cut down by quite a bit in the next couple of weeks. The other thing that this bill does, which it was not written as originally, is that it extends a survivor's right to obtain forensic medical exam from 96 hours to 120 hours from the time of the assault. And this got tacked onto the bill simply because one of the further right Tea Party Republicans who was on the committee had recently been briefed by his legislative staff around issues of sexual violence, and his staff had given him some materials and research saying best practices currently called for 120 hours. So when we presented this bill in front of committee, he piped up and said, hey, I just read something that said that 120 hours is actually currently best practice. Is there any way that we can fold this into the bill and we can increase access for survivors in that way? And we were sort of shocked because he's not typically a leader on this kind of issue. But we folded it into the bill, and I think it's just a really good example of you never know who is going to pipe up on this issue just because they've been briefed well by their staff, or we are talking about sexual violence, so the ways in which it's touched people's lives who aren't necessarily in the leadership on gendered violence or women's rights might have really thoughtful perspectives on this. The last one on SANE access is House Bill 4531, again by Representative Neave and carried in the House by Senator Zaffirni. It enables an individual under guardianship to get a SANE exam and make decisions about evidence regardless of the consent of their caretaker, to ensure that disabled individuals, in cases where the caretaker is the abuser or is negligent or is an accomplice, those people will still have access to an exam without their caretaker keeping them from that health access. And the reason I highlight this bill in particular is because it's a really good example of us getting together with disability advocates, with people who understand the bizarrely complex nature of consenting around guardianship and what kind of paperwork or notary we would need in place in order to get this to happen. It was a really big team effort, and I think it's an important message around that if you're going to do something that deals with intersectionality in the way that we want to, that make sure that we're protecting the most vulnerable individuals in our society, that effort takes work from a ton of different stakeholders, and we need to be really mindful of making sure that everyone is at the table when we make those decisions so that we don't make them wrong.
So now I'm going to talk a little bit about criminal and civil statute changes. The first bill is one we've already talked about a little bit, Senate Bill 194 by Senator Perry and Representative Moody. This bill really fixes a gap in the law in Texas. Previously, Texas was one of only a handful of states where indecent assault or groping was only a ticketable offense. This really created a hurdle to any kinds of prosecutions at all, because prosecutors and law enforcement were really willing to put in investigatory resources when the penalty was only a $150 fine and there was no jail time associated with this offense. We had tremendous witnesses who were survivors, who worked really hard on this bill and did a really great job testifying in support of the bill, and really carried this bill through the process. This is actually a bill that was filed in the 2007 legislative session and had, 2017 legislative session, and had the unfortunate fate of getting caught up in the bathroom bill fight. Because its caption was similar enough that it could have been a bill that the bathroom bill could have been tacked onto, and because the bathroom bill was really a piece of transgender hate legislation, and we didn't want to be a vehicle for that. This bill died in 2017, but it really was smooth sailing this last year, and we're really excited to have it become law. And it really is a result of the survivors who worked really hard during the legislative process to advocate for it. So it was a great victory. House Bill 3809 was by far, by Representative Goldman and Senator Watson, was by far the most dramatic legislative fight of the legislative session. This bill extends the statute of limitations for civil actions for a personal injury arising out of a sexual assault or abuse of a child, and it makes that statute of limitations 15, or it changes it from 15 years from the time that the child becomes age 18 to 30 years. Which is really a tremendous change and increases the likelihood that institutions that protect abusers are going to be held accountable. So this is really a really important change. So there were just a large number of folks who were involved in this success. Becky Leach, who is Representative Leach's wife, spoke out at the beginning of this process and told her survivor story in a really compelling way. In support of the bill. We had Olympic gymnasts come out and testify for the bill at a time when the bill was really sort of at a very delicate point. We had opposition from the Catholic Church and from the folks who don't like who don't like torts generally, the opposition to the trial bar. So it was a really contentious and dramatic fight, and we're just really grateful for everybody who came together to support this piece of legislation. It's a really big deal for survivors. So House Bill 98, many of y'all may have heard of past iterations of the revenge porn statute. This is Representative Gonzalez and Senator Huffman's latest effort at revenge porn legislation. It is legislation that addresses the intent issue, which is one of the issues that has made previous revenge porn statutes found unconstitutional by the criminal courts. However, if you have survivors who have this issue come up, district attorneys may still be really ambivalent about using this statute because it may still have constitutional problems. So know that although this was an effort to fix constitutional problems, it may not be totally fixed. That's the lowdown on House Bill 98. And finally, for this area of new laws, House Bill 1343 by Representative Leach and Senator Paxton. This bill requires survivors to object if they don't want a protective order in certain cases of criminal sexual abuse. So victims of continuous sexual abuse of a child, indecency with a child, sexual assault, aggravated sexual assault, stalking, trafficking of persons, continuous trafficking of persons, or compelled prostitution. This bill will now institute a mandatory protective order unless the survivor objects. The district attorney is supposed to file the protective order on their behalf in all these different sex crimes. So that's House Bill 1343.
And our last area of focus is human trafficking. Neither Becky nor I are human trafficking specialists. And human trafficking legislation typically comes directly out of the state level task force on human trafficking. I just wanted to highlight one bill because it is the human trafficking omnibus, a Senate Bill 20 from Senator Huffman and Representative Thompson. It creates a mandatory deferral program directing most people convicted of prostitution into community supervision and a commercially sexually exploited persons court program. It also increases access to NDAs for certain victims of human trafficking and compelled prostitution, and creates a special program for inpatient and outpatient care for victims of sex trafficking at a medical school in Houston, and creates new crimes for enabling online solicitation of prostitutes and enhances penalties for individuals who repeatedly solicit prostitutes. And then I guess we got cut off a little bit at the bottom, but it also repeals the deadline for the end of the human trafficking task force, which was set to expire this September, and just lets the human trafficking task force continue its work. And that's really it. We are about to send out this booklet that our graphic designer, Moody, did an incredible job on, that gives a good summary of our legislation that we just gave you, but also a pretty detailed breakdown of every single bill that had to do with sexual violence that passed through this legislature. And then if you have any questions whatsoever about what you read, please do not hesitate to send us an email. We can get you some clarifying language. And yeah, we are ready for your questions. Thanks.
Okay, there is one.
Oh, okay. So this is for Suzanne around the Lavinia Masters Act. I think that this is actually just
example.
Yes. Yeah, so this is not ex-law enforcement, this is example. Law enforcement must take possession of evidence. If we ever give this webinar again, we'll definitely change that to clarify it. Any other questions?
I had one on human trafficking, but it flew out of my mind. I was doing something else. So.
What hell is that?
Is that in 616?
I think so. So this question is also from Suzanne. Thank you. So yes, there's a new form. So as it stands, law enforcement can't keep someone from getting a SANE exam, but if they choose to not like functionally agree with the person's ability to get a SANE exam, they now have to fill out a form saying why, and then there's a couple of reasons around that, and I'm happy to email you the specific language after we get off here.
And then the question about, could you please read the last line on SB 20?
Oh,
yes.
Good question.
Can I look at it on yours since we're not screen sharing? Yeah, just can I see it?
It's not going to let me because I'm not the presenter. You're going to have to do it.
Oh, no. I mean, can you, because we're not screen sharing with you, can you pull up our PowerPoint presentation? It's just going to cut off.
Oh. Gotcha.
Yeah.
Just a second, y'all. We're working on this question about SB 20.
And repeals the expiration.
Oh, I think that's all it does is repeals the expiration date.
I just want to make sure I have that. Yeah. So the last, the last line on that slide that got cut off is just what I mentioned about repealing the expiration date of the task force, which was September 1st of this coming year, and it just repeals it. And what's our next question? For the kits on Senate Bill 71, what happens if the victim is deceased? Who will be notified about the kit being destroyed? So that's a really good question.
We've heard, I mean, this is sort of insider information. We've heard from DPS that they actually don't have a good way to notify people at the 5-year point. So this is probably something that's going to have to be solved with future legislation, or they're just not going to be able to destroy these kits in 5 years, is sort of where things are at right now. But I'm not sure that we can answer the question about whether or not the right to sort of keep a kit from being destroyed would survive a person.
Mm-hmm. There's also, we have some confusion about, there's provisions in other legislation around being able to get a SANE exam and forensic collection anonymously. And so there's some question about DPS compliance between notification and anonymity, especially if those survivors don't use the online tracking portal that will come online here in a couple of weeks called Track It. So we are in the process of implementing all of this legislation. Fortunately, we have a few years to realize the barriers to correct implementation and solve it with more legislation.
Can you explain HB 1343?
I can try. Is that that's the last one we talked about before, human trafficking legislation, right?
Yeah.
So HB 1343 basically is an attempt to, I'm not sure this isn't a gap that we identified, but a gap that the legislator identified, that some folks get protective orders when they have there's a criminal offense like a sexual assault. Some people get protective orders against their assailants or the defendants, and some people don't. And so this piece of legislation basically makes it mandatory for the district attorney to issue a protective order against the defendant in a sexual assault case, unless the victim objects and says, I don't want a protective order. In all cases, so in all cases, I'm not sure there's much more to it. It also enhances the penalty. If you violate the protective order, it makes it a higher penalty than it used to be for violation of a protective order. Those are the two things that the bill does. I'm not sure what motivated the bill. This is legislation that we were tracking, but that wasn't something that we came up with.
Okay, the next one is, they can't remember the bill number, but for the guardian being able to ask for the SANE exam,
Oh, right.
Is that only for disabled individuals, or does that also for children? And I'm guessing
Right.
children means under the age of 17 in the state of Texas.
Right. So my understanding is that this, that a different set of consenting exists around children. Is that your understanding as well?
Yeah, this
So this
legislation
is specifically for disabled individuals.
Right. And it was specifically trying to get at the problem of when the guardian of a disabled individual is either the abuser or is enabling the abuser, and how to help a disabled individual get access to a SANE exam and make decisions around evidence and care in that situation. House Bill 3801. I think I can try. 3809, yes. So this is a statute of limitations bill. So what that means is that's the amount of time that you have after an incident has occurred before you can bring a civil lawsuit. In this case, this is a civil statute of limitations. So that would be a damages action. So a good example of this would be the Larry Nassar case, the doctor who was abusing gymnasts at the Olympic gym here in Texas, and also at I guess a university in Michigan, was that? So there's an incident where he abuses a person, and that's when the time clock starts. Except in this case, in Texas, if you're a minor, the time clock doesn't actually really start till you turn 18. And so what this bill used to say, Texas law used to say, is that you have 15 years when it's a minor who's been sexually abused. You have 15 years from the time that person turns 18 to bring a lawsuit about the abuse. And the change in law in House Bill 3809 is that now you have 30 years. And the reason that's really important is that we know that it takes a long time for children who have been abused when they're adults to actually outcry and to try to do something about it. And so waiting into your 40s or 50s is really common.
And the other thing about this bill is that this is not only the statute of limitations for civil actions against a single person,
right,
but also against institutions that have knowingly and intentionally protected abusers from either civil or criminal repercussions for their actions. So say the Catholic Church or the Olympic Committee any of these larger organizations that have been known to shelter abusers are also culpable under this new civil action extension. Okay, thanks. Yes, I will get you that information, Suzanne, who asked for the information on law enforcement and SANE exams.
I got it.
All right. All right, any other questions, yeah? This is, oh, did you end it? No, I'm sorry. This is our email addresses in case you end up with more questions.
Okay, well, if that's it and we don't see any more questions coming in, we're going to wrap this up in a few minutes. Like Catherine said, her email address and Rebecca's email address are on this page. In about an hour, y'all will receive an email which will have the evaluation in it. Please fill it out, return it. There will be a link to the certificate of attendance as well in there, as well as a copy of this PowerPoint and the brochure that Maddie has, the beautiful brochure that Maddie has created for this. So if that's it and I don't see any more questions coming in, I'm going to wrap this up. Thank you so much, everyone, and thank you. All right, bye-bye.